So welcome to It Takes All Kinds, the ethics of dealing with difficult personalities. First of all, I'd like to introduce the panelists that are up here with me that will be speaking to you this afternoon. To my far left, to your far right, is Dr. Robert Simon. Dr. Simon is a nationally recognized leader in forensic psychology, consults on custody cases, and provides expert witness testimony. He's a director of the Association of Family and Conciliation Courts and serves on the editorial board of the Family Court Review. He is a member of the Executive Committee of the California Bar Court, formerly a senior member of the Ethics Committee of the California Psychological Association. He was recently appointed as a director of the World Congress on Family Law and Children's Rights, and he is a co-author of the book Forensic Psychology Consultation in Child Custody Litigation, a handbook for work product review, case preparation, and expert testimony. Just rolls right off the tongue.
Yeah, it's really catchy.
Yeah, work on that one.
And of course, he's an author of numerous articles. As you might expect, somebody with his resume, Dr. Simon lectures not just nationally but internationally and is very sought after. Immediately next to me is Michele Trausch. She is somewhat modest and told me that all I had to say is that she's recently retired and is formerly general counsel of a mid-sized litigation firm. That is true. She was a partner at Hanson Bridget LLP in San Francisco for years. She served as an attorney and counseled its lawyers on ethics and conflicts issues on a daily basis. She's also a frequent speaker and an author on ethical issues and has served as an expert witness and consultant on ethics and conflicts issues. To my right and to your far left is Joel Osman. Joel is a senior counsel at Parker Mills LLP in Los Angeles. He's a former principal of Osman and Associates. He's a litigation and trial attorney with past experience managing Travelers Southern California liability practice. He represents clients involving professional liability, general liability, product liability, construction defect, and commercial litigation. But he does focus much of his interest on the defense of lawyers and legal ethics. He's also a member and former chair of LA County Bar Association's Professional Responsibility and Ethics Committee. And I'm David Majchrzak. I'm an attorney with Kleindienst PC and work primarily out of our San Diego and Los Angeles offices. My practice, likewise, focuses on the law of lawyering. I consult with other attorneys who have interest in learning more about their ethics or risk management. I also defend them in legal malpractice and disciplinary matters. I'm an executive committee member of the San Diego County Bar Association. I am the immediate past president of the William L. Todd Jr. American Inn of Court, where I served 2 consecutive 2-year terms and happen to be a candidate for the San Diego County Bar Association Board of Directors. The thing that all of us have in common is that we are all members of COPRAC. If you haven't heard of COPRAC, let me tell you briefly what it is. We are appointed by the State Bar Board of Trustees. We work under the Office of Professional Competence. We have several primary duties. The one that you probably most associate with us is that we draft ethics opinions to provide instruction to the members of the California Bar about what their duties might be. In addition to being a member of COPRAC, I'm also the outgoing chair of our outreach committee, where we do programs like this, where we put on presentations for the people of California so that, again, we make sure that you know what your ethical duties are. We do it annually through 3 programs over here at the annual meeting, the Ethics Symposium, and the Solo and Small Firm Summit. But we also respond to requests from individual committees, bar associations that request us to lecture throughout the state. So if you have a need for somebody, please reach out to COPRAC. We're here to go ahead and serve the bar and make sure that everybody understands what their ethical duties are. If there's a particular topic that you believe that your group needs focus on, let us know. We're there for you. And also, I would mention this. To the extent that any of you are interested in ethics and I'm assuming because you're here on a Saturday afternoon that you just might be, like to work with incredibly smart people and a staff that is also very energetic, very helpful, and very educated on ethics, consider applying to be a member of COPRAC. Every year we're looking for new membership. Look for announcements at the State Bar website and information on how to apply toward the beginning of the year. At a personal level, this program represents both Robert's and my last service on COPRAC, and it's not because of the content of the presentation, just our terms are up. But I'll say that this has been the most rewarding experience that I've had outside of serving my clients and working with my firms in my career, and I'd highly encourage anybody that is potentially interested to consider applying. Of course, the State Bar does provide other resources available to you in terms of ethics. It does have on its webpage an ethics site. You can find the opinions that COPRAC has published as well as other information. I would certainly commend to you if you are interested at all in the evolving rules. I know we've been talking about changing rules in California now for well over a decade, but the 2014 Rules Revision Commission, as most of you probably know, has circulated those 68 rules for public comment. They're beginning to wrap things up, and I think we are on pace for them to be submitted in March 2017. You can find all of those drafts on that website. Of course, the State Bar also provides an ethics hotline. This serves an incredibly large amount of our membership. As you see, they field nearly 20,000 calls each year. In doing so, they can't provide ethics advice all the time, but what would happen is if you call up, you provide information so that they can confirm you're a member of the State Bar. They will go ahead and direct you to authorities that would address a hypothetical question that you might pose. I'm really proud that our State Bar offers this service. We are the only state in the country that does that. I know there are a lot of things California does unique in terms of the ethics world, but it certainly goes beyond how we number our roles, and this is one of those things I'm particularly proud of. So our topic today, of course, is dealing with difficult personalities. In past annual meetings, we've talked about how to deal with a particular difficult personality, difficult clients, and I know Robert and I have presented on that topic before. We're going to look at it a little bit differently today. We're going to look at it through the eyes of some different types of people that we come across other than just our clients. And we're going to address those in kind. We're going to look at how to deal with difficult witnesses, how to deal with difficult counsel, and how to deal with difficult judges. And of course, this all circles back to the same basic thing that we are concerned about whenever we talk about ethics. We need to make sure that we're dealing with people in a proper way, because if we don't do so, there's the parade of horribles that can follow. We can face discipline, we can face disqualification, we can face malpractice, we can lose fees, and of course, we can lose our reputation, which is really our bread and butter in this industry. So I'm going to pass this over right now for Robert, just for a quick introduction to us in terms of the question, who are difficult people, and what is it that makes them difficult?
Thank you, David. Before I answer your question, if I might just make a couple of other comments. As David mentioned, he and I are both finishing our 3-year term on COPRAC, and as a non-lawyer, not a member of the bar, it has been an amazing experience to serve on this committee and learn a lot about how the bar functions, but have the opportunity every month to sit with a bunch of really smart people who are very interested in best practice. And I've always thought of ethics as a guidebook to best practice. It's just been a real pleasure and a privilege to serve the bar as a psychologist and to work with these folks and some other really brilliant folks. And I agree with David, if you have an interest in ethics and in being a part of a monthly ethics think tank, COPRAC is a great way to serve. So I just want to say that. And thank each of my panel members, because they're all have been wonderful colleagues and very accepting of the psychologist in the room, which I have to tell you, if you want to know about them, I've got the goods on them. Anyway, what are difficult people? Well, there's no one type of person that's difficult or one reason that people are difficult. There's people who aren't normally difficult but can become difficult in certain situations. There's people who have a way of being complicated and irritating and frustrating in almost any setting.
Sorry about that, Robert.
Yeah, you're welcome. Your medicine's in the mail. But the similarity is this. Probably the most driving thing behind what makes people behave in a difficult way, be oppositional, reject advice that they've asked for, insist on doing things their way, even when their way is proven not to be the most effective way, challenge you at every turn. And these are people, of course, who are your clients sometimes, and often your clients who are paying you a lot of money and seeking your advice, who seem to want to reject it. And the thing that ties what makes people behave in a difficult way is fear. When people are afraid, when people feel that they don't have a good sense of efficacy, when they don't feel like they know what's going on, when they don't feel like they understand what's going on, when they feel out of control, when they feel not powerful, when they feel that somebody else has the reins over their future or over important decisions to them, anything that makes them feel fearful. One of the ways that some people respond to that is by becoming very difficult and hard to deal with. So what happens, of course, when people behave in a difficult way, when we confront difficult people, is that they bring out in us, quite reflexively, a kind of response set that actually makes them become more difficult. So it can be a self-fulfilling prophecy, and in that these are people who will tell you, well, I'm being difficult because look how you're treating me. I have to do this. When the genesis we're all helping professionals. We're trying to help and provide these human beings with solutions to things that are troubling them. So we really are trying to be helpful. And the genesis of the difficulty in the interaction, more often than not, but not always, is their fear. So it's important when somebody is behaving in a way with you that you're saying, this person's just, every time I offer a suggestion, they reject it. They're being oppositional, they're being defiant, they're just being difficult. What we want to do is assert our control and get back control over the interaction, but in fact that's exactly what will make them become more difficult.
Robert, are you saying that attorneys like to have control?
I think you just said that. Yeah. We all like to have control. Look, I mean, it's not just lawyers, by the way. All of us in this room, which I'll generally characterize, and therefore it's an overgeneralization and not an accurate characterization of everybody in the room, but most of us in this room are highly educated overachievers, very goal-oriented, very driven, people who demand a great deal of ourselves, and want to accomplish a lot and want to do it very well and achieve a great deal. So yes, we like to be in control. So we'll be coming back to this theme. I'm kind of going to be the color commentator as my co-panelists and your colleagues talk about different categories of difficult people. But what you'll see us coming back to over and over again is that underlying sense of fear, or that sense of not having efficacy, not having an internal locus of control over outcomes, which often makes people feel afraid. And we'll be talking about what it engenders in you and responses that you can use to help change the dynamic in your communication.
Okay, so for our first category of people, we're going to talk about difficult witnesses.
Okay, first of all, I'm not sure that Robert has characterized our roles exactly correctly. We're more like the straight man feeding him lines. And he's sort of like Johnny Carson, and we're all collectively Ed McMahon, if that's not too old a reference. Hold the mic closer, please. Sorry about that. I know you're not being difficult. And I also want to point out that difficult people, that's not a buzzword either for attorneys as a class or for legal ethicists. Legal ethicists are fun-loving people, and that's undoubtedly why you're all here in the afternoon on a Saturday. And we'll try not to make this too painful. I want to break down witnesses into three general categories and then consider the context in which you might encounter these witnesses. The first category is going to be non-party, third-party witnesses, people who are nominally not biased, nominally not interested in parties in whatever litigation you're involved in. The second category are going to be party witnesses who obviously have some degree of bias, and some of whom will be your own clients. And the third category is going to be expert witnesses about whom enough will be said later, Robert. In any event, we won't characterize who experts are other than the fact that there are people with particular expertise who are being paid to provide their testimony. And we're going to encounter these witnesses in a number of different contexts. If we're on the ball and efficient, we may want to pre-interview those witnesses to the extent that we're allowed to do that. We may encounter them in the context of a deposition setting. And then finally, we may also encounter them in the context of trial. And the behavior of these difficult witnesses is likely to change with setting, as are our focus as to what we're trying to achieve in a given setting. So let's begin with a non-party witness. And first of all, to make sure we get a little bit of ethics injected in this, not merely practical advice, does anybody remember if there's any rules of professional conduct that might have any bearing on your contact with a non-party witness? Or any witness about whom you're not sure? There is a rule that says that you're not supposed to have any contact with any witness who's represented. Now, generally speaking, if it is a non-party and you're contacting this person because you think they witnessed something which is at issue in your case, you're pretty safe on that one. But you want to be careful about that. It's okay for you to contact non-party witnesses. Sometimes it's even necessary for you to perform your evaluation functions in your case. But among the things you want to determine fairly early on is, am I correct in assuming that you are an unrepresented witness for whom there's no ethical prohibition to my contacting you? If the answer is anything other than an undiluted affirmative, stop. Find out what the heck's going on. You do not want to be in a position of having the bar call you up and saying, what's the deal here? You're talking to a represented party.
I'd go so far as saying it's not fairly early in the process. That should be really the first question after confirming who it is that you're talking to.
Joel, can I ask you a question about that?
As long as you're not difficult.
That is my picture up there. If a witness is technically unrepresented, in other words, the witness doesn't have their own attorney, but they have been hired by one of the attorneys in the cases as an expert, they are a retained expert to one side of the case, do the rules of professional conduct allow the opposing side to contact that witness?
No. And I assume you're baiting me with this because you know this as well as I do. You don't get to call up the other side's expert. If the other side's, if we encounter this actually in a different context, not having to deal with the witnesses, but in trying to secure experts or perhaps make sure that some experts are not available for the other side to secure their services. If an expert witness has been contacted by one side or the other, even if they have not accepted the retention, they're off limits. And furthermore, the expert, in order to maintain his own credibility, is going to make sure he tells you, I'm sorry, I can't talk to you about this one. I've already been contacted by the other side.
Well,
now, far be it for me to suggest that anybody would ever play games with this thing or ever actually try to take experts off the board by contacting every expert in the phone book before the other side gets to them. But it is theoretically possible to do that, and I suppose there might be some difficult lawyer out there who would try it.
Well, what if I want to hire that expert, not in this case, but I want to talk to him about a totally different case, and I want to hire him as my expert in that case?
That can be done. And in fact, some of the people who are now my favorite experts, and indeed some of my closest friends, I've met when they were on the other side of cases. There is a special exception for situations in which you have an expert witness that you have represented, not hired as your witness, but have represented. There is case law which precludes your ability to cross-examine that person. If they show up on the other side of your case, you owe a duty of loyalty and a duty of confidence to that former client of yours, which may make it impossible for you to effectively cross-examine that witness. But you can be against an expert on one day and hire them the next day, and there's no problem with that. Indeed, in the relatively small world of legal ethicists, that is not uncommon at all.
In fact, though, I'll go so far as to say that that's true not just of experts, though, but of all witnesses. If there's somebody that you've represented and there's subject matter in that representation that's related to what might be asked on examination, and they're a witness in a matter, that you would not be able to cross-examine that witness. And as a practical matter in such a case, what you do is you would get your client counsel that would participate in that deposition, and if need be in trial, at least as to that particular witness.
And even under those circumstances, you have to be particularly careful not to use any information which you acquired as a client confidence in prepping that other counsel to do the deposition. It's a very difficult situation. So
Joe, the reason I asked you the question, by the way, was not to bait you, but because as an expert witness, it is surprising to me how often the attorney for the other side contacts me, and I explain to them that I cannot speak with them, and they then think I'm being difficult, when in fact I am simply acting out of my responsibilities, and they're not. So I wanted to make sure that we got that in front of this group, because when we're talking about difficult witnesses, sometimes when we're experienced as being difficult, we're actually doing our jobs.
I think that's a very good point. We know you're not really difficult. So we're going to encounter these people in one of three contexts, these non-party, nominally non-partisan lay witnesses usually. You're going to interview them beforehand. You may take their deposition. You're going to examine them in the course of a trial. What do you do when you contact somebody like this and you go, they don't want to talk to you? They're being difficult because they don't want to be bothered. They're afraid because they're not used to speaking in public, or they're not used to people, their opinions really mattering. How are you going to overcome that difficulty, and how are you going to maintain your position as a person who's seeking their testimony, either because you want their testimony or because you want to discredit their testimony? You're not always going to be approaching them as their friend, and you certainly don't want to hold yourself out as their friend. Sometimes you want to find out what they know because you think it'll help you. Sometimes you think they're not going to help you and you want to find out how to discredit them. Robert, what are we supposed to do when our role may in fact not be all that friendly with these people?
Well, the reaction that your witness has to you doing your job is a reaction that you want to keep separate and not take responsibility for. And that's one of the things about managing difficult people, is when they react or overreact in a way that's hostile, that you look at how you're interacting with them, and if the way that you're interacting with them is, in your view, appropriate, that you don't take responsibility for their difficulty, but you respond to their difficulty in ways that may get them to become more cooperative. But in this particular instance, I think it's very helpful to explain what your duties are to this witness, because many witnesses don't know what your job is. They don't really understand what you're there to do, and what kind of responsibilities you have in performing your job. And so explaining to a witness, particularly a non-expert witness, is a professional witness who does this a lot, but somebody for whom this may be the first time they've ever been deposed or the first time they've ever been on cross-examination, to explain to them in advance what your job is and to be explicit about telling them that you're simply there to get information and reminding them that they're not the one on trial. I think that's very, very important, that this may feel difficult, and you may experience this as stressful. But my job is to get information from you, and this is part of a side effect of the adversarial process.
That's a really great segue into another little bit of ethical content in here. The second thing you do after you first determine whether this person is represented by somebody and thus not available to you to speak to is you explain to them who you are and why you are. And that's important because you cannot misrepresent to them who you are. You can't make the lay witness think that you're working for the other side because you think that's going to make them more likely to speak to you. And failure to be very, very clear about who you are and why you are reaching out to this person can have negative ethical consequences. It can also have negative evidentiary consequences for your case. I've seen issue sanctions sought and sometimes even granted if there's been a substantial material misrepresentation about you and what you're doing when you contact non-party witnesses. So you want to say, how do you do, Mr. Witness? My name is Joel Osman, and I represent client X. And I'm here to ask you about what you know about this incident that occurred on whatever date. Failure to do that, A, when it comes out, and it almost inevitably will, may harm whatever rapport you've developed with this witness, and it may have both ethical and evidentiary results. The second thing that you want to do is, what is the second thing you want to do? Sorry, I just lost the train of my thought there. You also want to be careful that the witness doesn't respond to you in some way that's colored by any sort of misapprehension on their part as to who you are and what you are. You're not their lawyer. You're not necessarily their friend. You may or may not end up being in a hostile or adverse situation, but it does not do you in your role as advocate or in your role as somebody who's trying to do their job ethically any good for them to have any sort of misapprehension of that. And again, of course, as always, you want to avoid the possibility of any sort of misconstruing of the relationship such that this person thinks you're their lawyer for some purpose, or that you're there to protect them in the course of being examined in various different contexts arising out of this case. That's not your job, that's not your role, and anything that you do that muddies that or makes it unclear, whether you do it intentionally or as part of some artifice to try to get this witness to say something you really want him to say, is A, not ethical, and B, has a strong possibility of coming back and biting you in some part you don't want to be bitten. So let's turn our attention to the next class of witness. I'm looking at the clock, thank you. We're talking about represented parties. Now, obviously, if the witness is a party who's represented by somebody other than you, the only time you're going to get to talk to them is either in deposition or in trial. I guess it's theoretically possible that if you're having a really good rapport with your opposing counsel, you may get to meet them and talk to them informally, but that, I think, is sort of an outlier. It doesn't happen all that often. And your relationship is going to be defined by those circumstances. If it's represented party witness, the only sort of conversation you're going to have is going to be in the nature of cross-examination, in which your roles are pretty clearly defined. And if that witness's counsel is on the ball, he will have prepped his witness in a way that there's not much chance you're going to be committing any sort of misrepresentation. But you still may yet encounter difficulty, either because of your obviously partisan roles or simply because the witness has got some underlying psychological issue that just makes them hard to deal with. Any particular insights about that, Robert?
Well, I think one of the things you want to do with all people when you're communicating in life, let alone in these complex interactions that take place in litigation, deposition, trial, is you want to form a relationship with them in which you establish some kind of rapport. And the important elements of establishing a rapport is that you understand what your job is, that you disclose that you understand what their job is, that you disclose that, and that you appreciate and understand what they may be experiencing. So, for example, when you bring in a non-party witness into a deposition that have never been deposed before, it's perfectly appropriate to say something to them along the lines of, I really appreciate your being here today. I know you received a subpoena, and that seems like it's pretty intense. And then explain what a subpoena is, and that it's sort of a formal way of requiring somebody's attendance, and that you know they're missing work, and you know it was inconvenient for them to get there today, and that you imagine they're a bit nervous about this, and that you understand that and appreciate that. So form rapport with them, form an alliance with them about the task that you have in front of you, the common task, which is you asking questions and them giving answers. This is different than seducing the witness and forming sort of a false sense of intimacy. It's simply polite and appropriate alliance building. So I think that's number one. But the other thing, of course, again, going back to what I said at the beginning about fear, when you start to notice that your witness is acting out of their fear, for example, giving very terse, very brief responses, or using body language that suggests that they're irritated or angry. What you want from that witness is their best answer, and their most honest answer, and their most complete answer. And you will not get that answer if, when they show you that they're irritated with you, you think that you've got them on the ropes and you get tougher with them. You'll actually increase their fear, and you'll increase their defensiveness, and increase whatever it is that's getting in the way of them giving you their best answer and their most complete answer. So what you want to do is read that signal that they're feeling afraid, make some statement overtly to them, if you wish, about, I see that this is hard for you, or I'm noticing that you're finding this very stressful. Offer them a break, or maybe even just throttle back your intensity a little bit for them. This is not a power game, and I think that the mistake I see many attorneys make when they're examining witnesses in depo or at trial is they want to assert their control over the witness. But in reality, it's not a power game. It's a question and answer task. That's what it is. And you want to use the tools that get the best and most complete answers, the most rapid from the client, and you should be unconcerned with whether or not they perceive you as being powerful or not. Okay? Because the truth of the matter is that you'll keep them there as long as you need to keep them there until you get the answers you want. So you do have that piece of power. But they've got a piece of power you will never have. And you must honor this piece of power. And that is, they're the only ones that make words come out of their mouth. Okay? The most powerful person in the courtroom is not the judge, it's the witness, because only the witness gives answers. And if you act in ways to relax your witness and decrease their fear, you'll get better answers. You'll get more honest answers, and you might get the answer you're looking for.
So here's a point. I'm sorry, question. Go ahead, sir. In the deposition context, to what degree do you have the freedom to tell the witness information that the lawyer for the other side doesn't want you to tell them?
I don't give you permission to communicate information to my client, or I don't have permission to ask my client that question. I mean, I'm just reading the rule. It's written rather broadly, or seems potentially provide grounds to say you can't communicate something that you were asking their lawyers that want you to ask.
Well, I don't really think that's an ethics question as much as it is a discovery question. So let's talk a little bit about the differences between deposition and trial, and maybe we can wrap the answer to that. In deposition is a discovery advice, in quotes. We're here to discover what the witness knows. And that can be hard enough. What we're not here to do is to play power games, as Robert suggests. And furthermore, I'm not there to give him a preview of my best cross-examination. I want to save my best stuff for later. I'm not there to gratify my ego or to prove to that witness how really awful it's going to be if they go forward with their terrible case. A, it's never once worked in the last 35 years, and B, I'd rather save it for later if I actually have to do it. So you want to bear in mind what Robert has suggested. You want to do the things that you need to do to dial down the adversariness of the proceeding. Now, to your question specifically, well, what if you ask a question or say something that the other side doesn't like or the other counsel doesn't like? I forbid you to say this to my client or to ask my client? I'm sorry, I'm in discovery. We're on the record. I don't work for you. And if it were not uncivil, I would respond in 2 words, the first of which starts with an F.
Well, more fundamentally to that question, though, 1-200, in terms of the prohibition on contact with the represented party, is that you can't contact them without their attorney present, and clearly there are attorneys in that room. I mean, you are communicating with them at the deposition. So if they have somebody that's representing them telling you that, it's the response probably for me is, too bad, so sad. Probably in a more polite way, but
It should be noted, David, it's always more polite than I am.
Yeah, you're going to have that general conversation, but that's certainly ethically permissible. I will disagree with Joel on one point, though, but I think it's subject of a different presentation, and that's whether you should, elicit the best deposition testimony at deposition or save it for later. From my experience in general, for what it's worth, lining up good discovery responses, including good depositions, is the way to build your case and resolve it short of trial.
So young, so not cynical.
Just to answer
my analogy on the deposition is, look, this deponent, this witness is a piece of fruit. I'm here to squeeze every bit of information, every bit of juice out of that witness I can. How I use it, or what I'm going to do to prove them that I could make a monkey out of them later, is for later. Now, obviously, people of reasonable smarts differ on this point, and it may not be because I'm old and cynical. But, if when we do that presentation, that's the story I'll tell then, too. I'm sorry, Robert, I didn't mean to
If I may
interrupt
just
you.
address your question, again, I'm thinking like a non-lawyer. It strikes me that if an attorney ethically could say, you may not ask the deponent that question, there'd be no discovery. You wouldn't let them answer anything. You may not ask them anything. Because, if you're the opposing lawyer, you're there to defend the deposition, but you know darn well that you'd really rather it not take place. You'd really rather them not do pretrial discovery. So, on its face, you can register your objection, of course, and the judge can rule at trial as to whether that comes in, but I don't know that the lawyer has the ability to say you can't ask that question or you can't say that to my client. And I don't think ethics bears on that. I think that's really more civil procedure.
Discovery.
Yeah, I mean, more likely
Right.
what you're going to get is
You
you're
can
going to
do that.
draw an objection or an instruction not to answer, and then it's off to the judge if you can't work it out. But the ethical prohibition in 1-200, not so much. That's only for when the witness is present without counsel.
So, Joel, I have a hypo for you. I think we all kind of get, there's an individual who's represented by counsel, you can't talk to him. Let's talk about the case where you're opposed to a corporation, a business of some sort, and the witnesses that will be produced in deposition include a senior vice president and the mailroom clerk. Now, can you talk to either one of those people? They're not the actual defendant. The defendant's the entity, the corporation. Can you talk to either one of them before, even though the corporation is defended by counsel?
No. The corporation is a person, even though it's a person comprised of many different individuals. And it would be both ethically wrong and evidentiary bad evidence if...
We got it.
Thank you. Okay, long day. You can't go out and call up the individuals because they are effectively the corporation. There is no General Motors a person. It's a legal fiction, obviously. So if the corporate VP of General Motors or the mailroom of General Motors is somebody you want to talk to, you're going to have to go to do that through counsel as if you were talking to the client themselves. And that's true in most settings in which you're talking to some subordinate person in a corporate, even if it's not a corporation, even if it's a partnership or an employer. It's just, you don't want to go there. It's probably not allowed at all, but you just don't want to take the risk. Do it clean and go through the opposing counsel. Now, I'm getting the move along signal here, so I want to skip to the expert witnesses who pose other challenges for you. First and foremost, they're smarter than you, or they may be. And
They know more about their area of expertise. That doesn't make them smarter than you.
Okay, but in my simple terms, my caution to myself and to anybody I've ever spoken to about this is, don't try to out-expert the expert. You're there, again, to squeeze that piece of fruit and get all the juice you can out of them, to find out what they know, where they got that information, and what gaps there are in that information, because therein is where you're going to do your best work on cross-examination. If they've been given a set of facts to assume and you start changing variables on them, then logically their opinion is going to change. And if it doesn't, they're not a very honest expert, and you can get them for that way. Likewise, you can turn them around if need be and start feeding them alternative facts and try to squeeze testimony you want out of them based on alternative assumed facts. But the thing that you cannot do that doesn't play well with and makes the witness more difficult, because they, not unlike lawyers, often have a fairly high opinion of themselves, is to try to prove that you're smarter than them. That's not going to get you in the right direction. The other thing that you should not do is A, lose sight of the fact that this person is being paid to be there, or B, insult them too much about that fact. Certainly not in deposition. Isn't it a fact, sir, that you're a hired gun? Yeah, right. That's going to really engender a nice positive response. It's going to get you a nice, easy deposition. And the same thing is true if you're doing it at trial. Everybody in the room is going to know that this is the other side's expert, a.k.a. hired gun. We were actually talking this afternoon in the hall about this because every jury I've ever interviewed after the fact of a verdict has said, well, we just sort of balanced the two experts and figured as long as there was one on each side, that wasn't really going to be dispositive. Unless you have an expert like Robert who's just extraordinarily charismatic and carries the day and is totally non-difficult, the chances are the experts are going to get a little bit balanced out by the trier of fact, but you still have to make sure that everybody understands, just to be sure and not to be too insulting, but you are being paid to do this work, right? And who's paying you to offer these opinions? And the other side for sure is going to do that to your guy, so you want to get it out. You want to get ahead of that question before some smart guy on the other side thinks he's going to, really put it to you by proving your hired gun is just some, opinion for hire. Any particular insights you want to offer on this one, Robert? Because we got to roll this along a little bit.
You mentioned earlier about experts having a high opinion of themselves, just like lawyers do, and you don't put yourself in front of a cross-examining attorney or in front of a judge or a jury unless you think you know your stuff, unless you're an idiot. That's an expert. So yes, it's true. You have an ego, and that's absolutely the case. And if the attorney goes to challenge you that they're smarter than you, they know more psychology than you, that's, in my case, psychology, that's going to, and what if they do? And by the way, there are attorneys who do know more psychology than me, and one of them's here, not in the room, thank goodness. But that will engender fear in the witness, right? I'm going to be shown to not be the sharpest knife in the psychological drawer in this room right now, and that witness is going to become a difficult witness to deal with, and you're not going to get their best testimony. When you have an opposing expert, I'm going to give you a secret about how to get the best from your opposing expert. When you have an opposing expert on the witness stand, flatter them. They'll sing like a bird. They will pontificate until the day is dark, because that's their ego talking, because it's the antithesis of fear. They're being told that they're really smart, they're being told they're really qualified, they're being told their opinions are very helpful, they're an expert in their field, and if you flatter them, they will work for you. If you challenge them, they will become difficult and they'll shut down. So experts are no different. In fact, because the expert has that opinion that they're the smartest person in the room and they require some care and feeding, they are easily reverted into a difficult person because their fear is very easily brought to the surface. Okay? So go the other way. This is like Aikido. If any of you have ever studied the martial art of Aikido, the thing that makes it unique is you use your opponent's energy against them in Aikido. It's a circle of energy. So they come at you and you reverse it and you turn their energy back on them. That's what you do with difficult people, including the expert with the ego.
I should admit, by the way, that this is one of those moments of do as I say, not as I do, because there have been times when I've, for one reason or another, gotten my back up, been difficult, caused the witness undue unpleasantness just because I had some internal need to do that, and occasionally it comes back and bites you, or you certainly hear about it. I deposed a legal ethicist once in a legal malpractice case, and it's not a very big community, and I heard thereafter from several sources about what a total jerk I had been. By the way, we won the case, but that doesn't excuse it, and you should really listen to what I say and not what I do.
Well, I think that emphasizes that this is a human endeavor, and that at the end of the day, no matter how experienced and how skilled you are and how prepared you are, you're a human being that walks into that courtroom. And your vulnerability as a human being is with you at all times and can surface at any point along the way. The same, by the way, is true for the expert. I've sat on the witness stand as an expert, knowing that the attorney questioning me knew nothing about what they were asking me, and I went for the jugular and thought about it from the witness box and thought about it later and thought, that was really stupid. Instead of showing yourself to be an expert, you showed yourself to be partisan. And experts, if they're smart, aren't partisan, they're educators. So, we all do that, Joel.
Now you know why we love this guy, because now I feel sort of absolved and I feel better about it.
Yeah, I'm sending you a bill. Don't worry.
Okay, we're running out of time here, so I want to flash through the next two slides very quickly. Remember, when you're talking to third parties and to the other side, obviously, there isn't any confidentiality. Likewise, there's no confidentiality when you're talking to your expert in preparation for it. If the other side is doing his job right and exercises his rights under CCP 2034D, he's going to be entitled to look at every single piece of paper and every single thing that you've talked to and given your expert. That's where he's going to get his good cross-examination from. And if you have conversations with the expert that the other side can inquire about and are remembered, he's going to get those too. Also, remember when you're talking to witnesses who are not difficult, but who are cooperative. There's cooperative and then there's too cooperative. The witness who says, I'll say anything you want, nah, you don't want to do that. You have an ethical obligation to not suborn perjury. You can put yourself in a position to be subject to both criminal prosecution and state bar compliance, ethical prosecution for having done that. And again, whatever price there may be attached to the testimony, except when you're paying Robert's bill, it may be too high for the to be in the client's best interest.
Okay, so you know these people, you've certainly seen them before, the difficult attorneys. Now, in a system of advocacy, there's really no secret that this is going to be a natural ground for there to be a difficult relationship. I want to start off this by taking a quick survey. I promise there won't be any follow-up questions to any individuals, but I do want those to raise their hand that do have affirmative response. I just want to talk about the concept of zealous advocacy. How many people here before have heard that we should be zealous advocates? Okay, how many people, in fact, for people on the video, the vast majority of the room raised their hands, if not everybody. Now, how many people think that we have a duty of zealous advocacy? Okay, I see again, the vast majority of the people in the room raising their hands. I'll submit to you that there's not an affirmative duty to act as a zealous advocate. And, I think it's important for us to step back and consider what a zealot is. When we go back, and don't worry, I won't bore you with a long history lesson. I'm going to get through this section as quickly as I can for timing purposes. Now, originally it referred to a member of a fairly aggressive sect in the 1st century AD that was fighting over land in Palestine because the Judeans wanted to control it of the area, and the Roman Empire had it. Funny thing, the battle over that land hasn't really ended, how many years later. But the concept behind what a zealot is hasn't really changed over time. It's still fundamentally a person who's fanatical and unwavering in their pursuit of something. And that's really not what we're supposed to be as attorneys. If you look, the rules of professional conduct contain no express duty to act as a zealous advocate. In fact, there used to be a mention of it in the old ABA Model Rule 1.3, but that's since been abridged. And the term zealous doesn't appear anywhere in the rules of professional conduct for California. I got it, Joel. It does appear 3 times in the preamble for the ABA model rules. But I think it's important to consider the context that it's in, and consider this when we're talking about how to deal with other attorneys. First, in paragraph 2, it says, as an advocate, a lawyer zealously asserts the client's position under the rules of the adversary system. So we need to take in context what our obligations are. A lawyer can be a zealous advocate on behalf of a client and at the same time assume that justice is being done. Again, we're really taking it out of that concept of somebody who's in it, at all costs and doing whatever is being taken care of. But I think the most important guidance really comes from paragraph 9, which recognizes the following. Lawyers' obligation is zealously to protect and pursue a client's legitimate interests within the bounds of the law while maintaining a professional, courteous, and civil attitude toward all persons involved in the legal system. It hardly seems that there's that suggestion that somebody act as a true zealot. Now, the appellate courts have certainly commented on this, and the In re SC case, if you haven't read it, provides some of the most fascinating commentary. A lot of times we'll sit down, we'll read an opinion, and it just gives us a sort of principle of the law, but I'll mention to you that this happens to be a very interesting read. And it starts off that way with the following sentence. This is an appeal run amok. Not only does the appeal lack merit, the opposing brief is a textbook example of what an appellate brief should not be. And then it goes on to explain the various ways that it was deficient. Violated the rules of court, ignored the standards of review, failed to support arguments with citation to authority. It unjustly challenged the opponent's integrity, and on top of that, happened to also attack the trial judge. Often, a very good means of getting an appeal granted when we attack a fellow member wearing a robe of the people up on the Court of Appeal who potentially worked with the same judge. In fact, this brief went on, to even criticize the client's own daughter, who was complaining of sexual molestation, by referring that her disability had made her more akin to broccoli, and characterizing her complaints as her versions of her story. So in addition to being a poor piece of civility, it was also a poor piece of advocacy. And then exactly is there a duty of civility if there's not one to be a zealous advocate? And at least in the past, there had been one. Previously, 6068, subdivision F. And taking a step back, we all know that Business and Professions Code 6068 is one of the guiding principles that we have in the State Bar Act. That's what gives us the list of all of the duties that attorneys have. So when in doubt, if there's only one place to consult, start at 6068. But F used to tell us that lawyers were required to abstain from all offensive personality. I'll suggest to you that not only is that difficult to do, but that's somewhat of an ambiguous standard. And in fact, that's what happened. The Ninth Circuit in the United States back 20 years ago came down with an opinion saying that this was an unconstitutional term for California to require its attorneys to abstain from all offensive personality because we couldn't tell exactly what that is.
But it did make my life a lot easier.
I think we know it when we see it, don't we?
Okay. So it's what has happened is the State Bar Act has been modified along the way. In 6068 is one of those sections, and Subdivision B provides that we still have to maintain the respect due to the courts of justice and judicial officers. I'll suggest to you, at least from my perspective, that is at least equally ambiguous as to abstaining from all offensive personality, but that has withstood the test of time and is still the standard that we need to follow. What the State Bar did, though, in addition to that change by the legislature, was, of course, it adopted attorney guidelines of civility and professionalism. Now, where those are not mandated for attorneys to follow, I'll suggest to you that those are incredibly good guidelines. And there's a certain service that we do to our clients when we follow them. And I think we've gotten into a little bit about the hazards of an advocacy system. When you're combative with somebody, that leads to these disputes that are incredibly time-consuming, and they get in the way of what our fundamental job is. And I think when we consider what we are there to do, we are aligned, even with opposing counsel, in our ultimate goal. And that's, we're there to resolve the dispute for our clients that they couldn't resolve themselves. Now, we may have different interpretations about the desired outcome in the resolution of that dispute, but that's what we're there for. Whether it's through a negotiation or through trial or some other method, we're there to go ahead and get an answer for our client. The more that we stand in the way of doing that by engaging in that offensive personality, by being combative unnecessarily so with somebody, we're delaying that goal that our client has, and we're potentially, depending on how our fee engagement is set up, costing them more money to do so. And I'll submit to you that by engaging in that type of combative personality, you're potentially breaching your duty of loyalty to your client. Some important takeaways that I think that we get from the guidelines is essentially those points that we've talked about. Maintaining dignity, decorum, and courtesy, and making sure that you're there and the battles that you're fighting are the important ones. Don't go over and create unnecessary problems. Now, I'm going to limit my analysis here, partly due to time, to really three types of overzealousness that I see in an opponent along the way. And I'll address each of these in turn. It's misrepresentations to the court, frivolous claims, and delay tactics. I'll caution you that my advice would be that any time we see these, our initial urge is to go ahead and respond in kind. I mean, each of these is potentially inflammatory to us. And, again, we like to have control of the situation, but it's important not to for the reasons that I stated. We want to economically revise this and efficiently do so for our client's benefit. So first with misrepresentations. Of course, we've come across situations where an unethical lawyer may attempt to gain an easy advantage in the case by misrepresenting something. It could be something regarding a discovery dispute, saying that, this person said this, that, or the other thing. It could be a case of a service where they believe that they make a representation in the court that they did certain things in order to effectuate service of summons on a defendant when they had not, in fact, done so. Of course, this is something that ethically can't be done. Business and Profession Code 6106 precludes moral turpitude, dishonesty, or corruption, and Rule 5-200 requires us to avoid misleading not only the courts but also judicial officers and juries along the way. This, of course, mirrors the language in another court that we may not have in state court, principally under FRCP Rule 11, which when an attorney is filing something requires them to go ahead and verify that everything is being said has an actual factual evidentiary basis for it, and then we can engage in a Rule 5 motion if they violated that. It's somewhat akin to the CCP 128.7 for those that aren't familiar with FRCP 5. You give a 21-day safe harbor provision. Essentially, let the other side put them on notice that, hey, you've made a misrepresentation along the way, and you need to go ahead and correct that. The next step that we're talking about are those attorneys that make frivolous claims. 3-200 prohibits certain objectives of employment, and we don't want, of course, attorneys to go ahead and raise issues that have no merit to it for the same reason that we go back to earlier. It wastes the client's time. It wastes resources along the way, including client money. And just not all suits or frankly, all defenses are meritorious. And I know Joel, who represents a lot of plaintiffs, would certainly agree with this. Directing litigation down a rabbit hole, whether it's on an affirmative claim or a lot of times on affirmative defenses that defendants may raise along the way, it does that same thing. It wastes the resources. And again, you've got that similar remedy that I just referred to in the federal rule, although in state court I think this is only limited really to frivolous claims rather than to misrepresentations. And that's the remedy under 128.7. Again, you would put the other side on notice, give them 21 days to go ahead and withdraw whatever position it is that they have. And if they don't, you can get sanctions from them. The third topic is really delay tactics. And again, we've sort of covered this again, so I'm not going to go through it further. It just wastes time, it wastes resources, and it doesn't get to your client's goal, which is ultimately to resolve the dispute. In federal court, again, they have a remedy that we don't necessarily have in state court, but I figured I'd raise it. 28 U.S.C. 1927 allows, for anybody that unnecessarily multiplies proceedings, of course, can ultimately be held accountable for that additional expense, including the attorney fees and costs involved in the case created by delays in the process. So we do have a few remedies at law that we have to deal with, and then I'm going to kick it over to Robert to give you probably the practical ways of addressing these situations. First of all, we can report. Again, I'll submit to you that a lot of these tactics along the way are unethical for the reasons that I've described. And you can certainly go ahead and report opposing counsel who's abusing the process of the state bar. In California, unlike other jurisdictions, though, there is no mandate that you do so. And sometimes, frankly, working things out rather than reporting might be a good tack to take simply because by reporting, you're just escalating the situation. And then we've discussed both FRCP 11 and 28 U.S.C. 1927. So a couple things you can't do. First, you can't have a vengeance settlement. You don't like what a party did. You can't make as part of a resolution of the case some prohibition on their practice. Sometimes, and a lot of times, you might see this from a defendant's suggestion to a plaintiff, perhaps an employment attorney saying, hey, I know you're aware of this particular bad practice that's going on, or at least one that you perceive as being bad. As part of this resolution with your employee against the employer that I represent, I want you to promise that you're not going to bring these similar types of lawsuits against my client in the future. Under 1-500, of course, you can't do that. Similarly, you can't threaten to use it as an advantage, some type of disciplinary threat or criminal threat against the attorney. 5-100 prohibits that. And, of course, you can't use the media to go ahead and litigate a case, including the bad acts of opposing counsel. You're somewhat limited in what you can say about the case, which is basically these are the facts, that this is what's being alleged in the case. So with that as a background, Robert, we've got these people that, again, probably like us, want to have control over the situation. They're ideologically opposed to us in terms of how this dispute's going to be resolved. Once we get into this situation where they're escalating it by engaging in these practices that we don't believe are proper, what can we do from a practical matter to dissuade them from doing that?
Well, a couple of thoughts are coming to mind. First thing is that more aggressive tactics don't necessarily change or at all change the facts of the case. Keep that in mind. It's form over substance. The substance of the case is the substance of the case. If you have a strong case and the other side has a weak case and they're using strong tactics, You don't have to fight fire with fire because, first of all, it's only going to spin up the conflict in the case, but it doesn't change the facts of the case. I think what can happen in these cases, and what I work primarily in the family law field where the emotions run very, very high, and because we're dealing often with people's children, which is, a world of its own. And so you've got an attorney on one side of the case using very aggressive, very assertive tactics, and the other side, the other attorney prefers to litigate in a more holistic, family-centered way, sort of spare the conflict and preserve the children. And their client begins to feel like their attorney is weak and their case is weak because they're not fighting fire with fire, okay? And that's where you have to go back to your moral center and your moral core and remind yourself and your client that while the client determines the goals of the case, you determine how you get there. That is your job. And that if your client is encouraging you to use more aggressive or assertive tactics that you don't think are going to be effective, and are more likely than not to be ineffective, actually, and perhaps destructive, I go back to that F word, fear. What are you afraid of? What is it that you are afraid will happen if you don't adopt those tactics? Do you think the other side will see you as weak? Do you think the client will fire you and go on to another lawyer? So it's also about self-management. When your client is, whether it's a family law case or any kind of a case, your client is exhorting you to take on more aggressive and assertive tactics. Think about the client's state of mind. Think about the client's worries and fears. How are they perceiving you? Are they perceiving your approach to the case as signaling or suggesting that they don't have a strong case? Are they afraid the other side is seeing them as weak? These are things simply to explore and to talk about with the client, and to try to take their temperature and educate them, if you will, about things. Ultimately, at the end of the day, we have difficult clients because they're in a difficult situation. We have difficult clients because they are difficult personalities. It's important to understand the difference. The difficult client in the difficult situation will, in other places in their life and in their own life history, have been a much more reasonable, rational human being, whereas the difficult person is somebody who leaves wreckage in their wake. And make that differentiation and that distinction, because you're going to want to manage these individuals differently. One of the key management tools for the difficult person, the person who's difficult everywhere, is to find your way out of the case, because they won't change. The person in a difficult situation who's really tapped into a lot of fear, a lot of anxiety, a lot of worry, you can be a counselor at law at that point and have a reasonable amount of success many times by counseling them through it.
And I apologize for rushing through this, and I'm just trying to catch up on time, make sure that we get you through this. I swear I don't.
You're being difficult, David.
I swear I don't usually talk this quickly, but I want to make sure that we get the material in here for you. Two other quick categories of potentially difficult situations with counsel, and then we'll go ahead and move on to our last subject of the difficult judges. First is the forgetful, careless counsel. And what we're really looking at here is the inadvertent disclosures, which is more or less one of the topics that we talked about in Arden this year, if you remember that Supreme Court case of Arden versus the City of Los Angeles. Again, it confirmed the general standard that's set forth in both State Fund and in RICO in years past, and that's that Evidence Code 912, the waiver of the privilege, really doesn't come into play. If something's produced that shouldn't have been, there's no gotcha theory to the waiver. And this is increasingly important as we continue to litigate in the volumes and reams of papers that we exchange or electronically stored information increases. The perfect production just doesn't happen anymore, and it's probably unreasonable to do so in cases when you have hundreds of thousands of pages of documents being exchanged. Again, the rule for those that aren't familiar with it is simply, as soon as you read something that you believe is privileged along the way, you need to stop reading it. You immediately notify the sender, and then you have two options. You can either work it out between the two of you, or failing that, you go to the court and ask for guidance on the subject. There is not the need immediately to go ahead and turn it over if you believe that it's something that should have been produced and is not privileged along the way. But you can't read it further until you have that resolution of that issue. The other issue I want to address involves with co-counsel. There are a couple small duties that come up along the way. There are no small duties. First of all is to keep in mind when you're working with somebody else that you still continue to owe that duty of competency to your client regardless of how you've agreed to allocate your duties with co-counsel. That is, even if you say, if Joel's working with me and he said, you know what, Dave's supposed to be handling X. If I'm not doing X, even if I've agreed to do that, Joel's got that duty to make sure that it gets done along the way. I just want to make sure that I didn't use the example the other way. And along those lines, you can't assist with violations of the rule. And I believe that allowing that other attorney to act incompetently, to not satisfy the duties and not raising that up and holding them to task for what they need to do for your joint client might in fact be assisting them with violations along the way. Make sure that any allocations of fees are approved by the client. Now, this rule may be changing. Right now, 2-200 doesn't really have a timing for the allocation of the fee split. The new proposed rule, if you look at it, by the way, requires not only that it be disclosed to the client, but the client approve it in writing and do so, I forget if it's as soon as possible or if it's just merely at the beginning of the representation. But in any event, you can't wait to the end for the money coming in anymore to go ahead and work that out and have the client sign off on it. I'm going to move on just because we're running short on time. The last issue, and I've seen this popping up actually a number of times, which is why I bring this to your attention, is what happens when co-counsel is disciplined along the way. And I think that this is happening more and more, especially in the small firm context, when you have people that are routinely working together along the way, pooling their resources, sharing the risk, even though they may not be a firm. Keep tabs on your co-counsel. If you know that they're having problems in a matter and may be subject to discipline, make sure that you're aware of it, because if they're suspended or disbarred along the way, you can't rely on them to perform services anymore for the client. You also wind up having a change in your fee sharing, because as non-attorneys, of course, they can't receive fees for work that they do following their suspension or disbarment. Of course, they're still entitled to fees that might have been earned before that time, but they can't get any later on. And you need to make sure that you're not delegating tasks to them and relying on them to do work that they're not performed to do. And we look to 1-320 for what those parameters are, which is a wonderful guide to us in terms of what constitutes legal work and what doesn't. The things you can do, of course, they can do prep work, which includes research and drafting, so long as the person that's still a member in good standing is reviewing and signing the documents before they go out. They can communicate, but it's only regarding scheduling, billing, or confirming receipt of materials. And they can accompany lawyers along to proceedings. They just can't be the lead in them. They can't render legal consultations. They can't make appearances. And, of course, they can't negotiate on behalf of the client. With that said, we're going to move over to our last group of people that's potentially difficult. And this, perhaps, for me, is the most difficult one to deal with, because this is the person that's controlling the room that we go to at the end of the day, and that's the difficult judge.
And the problem is I have 15 minutes to do this, but I'll do it. So I'm sure no one in this room has ever encountered a difficult judge before. So if one pops up on your radar, you'll know what to do going forward. The problem with a difficult judge, of course, is the balance of power is totally different from the other types of witnesses and people that we've just talked about this afternoon. Here the judge has the power. The lawyer does not have the power, and that shifts things around a little bit. You want to address that briefly?
Well, it's a very, very different dynamic. And the truth of the matter is that with the difficult judge, there's often less you can do realistically in the moment when you're encountering that difficult judge than you can in dealing with a difficult witness or a difficult counsel or a difficult coworker. And I just think it's important to know that and let that truth be known. I think when you've got a difficult judge, you certainly don't want to become weak and you don't want to become a pushover. I think this is where you need to practice, being respectful and in communicating with the judge in ways that are brief, informative, firm, and fair. The BIF standard: brief, informative, firm, and fair.
That's good. That's good. So I'm going to zip through this real fast. These are pretty obvious. You're dealing with somebody who has power over you, over your case, somewhat over your client. Be prepared is really what this comes down to. Know who this judge is, especially if it's a court you're not usually in or not familiar with. Research, find these things out. We're talking about judicial assignments. Are you in a court where you have any control over who your judge is or not? Sometimes you do, sometimes you don't, but usually you don't. Is this a master calendar situation where you're not going to be running into the law and motion judge to try your case, or is this somebody you're stuck with for the whole case? How do you learn about the judge? Online resources, circulate a message through your firm, through your colleagues, who has appeared in front of this person, what information can they give you about how to deal with him or her, especially if there's a reputation behind the judge that may not be totally favorable. Again, just zipping through this real fast, you can see getting yourself ready to be in front of the judge is probably the most important thing you can do. The rules of professional conduct include 3-110, which provides that we must act competently at all times, and that would include being prepared. And being prepared may include finding out who the judge is and what you need to do so as not to annoy the judge. I'll say that politely.
Practice tip here. If you're a Los Angeles lawyer, don't ever walk into a San Diego courtroom and sit and allow the judge to think that you didn't bother to read the local rules.
Yeah, good point. Good point. That's exactly the type of thing we're talking about. So if you're familiar with your own, county's courts, and you're moving into a different county, especially one you haven't been in before, with judges whose names you don't know who these people are. I'm not going to go through this. 170.6, if you want to challenge a judge in California, very specific rules. I do remember a situation where a judge the attorney was trying to challenge a judge to just get the judge off his or her particular case, and didn't exactly say the wording that you find in 170.6, and the request for disqualification or recusal if that judge was denied just for not having the appropriate wording. If you want to challenge a judge, walk in with the statute and read it right off the statute.